this meeting of the Standing Committee on Agriculture, Environmental Affairs and Development Planning. Today is Wednesday, 8th of November at 9 o'clock, 2021, and we are continuing our deliberation on the Biodiversity Bill of the Western Cape. Thank you very much for each and everyone who made time this morning to join us. And I'm first going to start by just introducing myself. I'm Hendrikus van der Westhuizen, privileged to be chairperson of this committee. And we also have some members of this committee online. And perhaps if I could just give them an opportunity to introduce themselves. Thank you.
Deirdre Bartman, member of the committee.
Thank you, and you're most welcome.
Mathodi Maseko, member of the Standing Committee.
Pat Maran, member of this committee.
Daniel Smith, alternate member of this committee.
Good, thank you. Those are all the names that I see here on my list, and a warm welcome to you all. Also to those members that are joining us and that were not able to join us yesterday. Again, if I can give over to the department. I don't know if it's Ms. Burs. I do not see the HOD's name on my list. Will you, or Ms. Laros, will you please introduce the team from your side?
Good morning, Chairperson. Good morning, honourable members. I'm Marlene Laros. I'm Director for Biodiversity and Coastal Management. With me, I have my Chief Director, Ms. Karen Shippey, and we are all from that is the representation from the department. I'd also like to highlight that from Cape Nature we have Ms. Coral Burse, and from the Department of the Premier in support we have Mr. Lionel van der Schyff. Thank you, Chairperson.
Good, thank you. And then if I could also give our legal advisor from the Provincial Parliament an opportunity to introduce himself.
Thank you, Chairperson. Good morning. Good morning also to the members and the other colleagues on the platform. My name is Romeo. My surname is Masto. I'm the legal advisor for the Provincial Parliament assisting this committee.
Good, thank you. And then we also have another legal advisor from the Department of the Premier online. We see you, Mr. van der Schyff. You're welcome to introduce yourself.
Good morning, Lionel van der Schyff, Department of the Premier. Legal.
Good, thank you very much, and a warm welcome also to you. Good, thank you. Welcome, sir. And then we also have our support staff from the WCPP, who has made it possible for us to meet in this way this morning. Our procedural officer, Ms. Sherine Niekerk, then also Ms. Nomfundo. I hope you can hear me well. I'm getting a message here on my screen, bad network quality, and I'm therefore going to switch off my video for now. Ladies and gentlemen, yesterday we went through all the comments that were received in a matrix that was kindly put together for us, and we if I could ask that it again be beamed onto the screen, while I'm asking Ms. Niekerk also to just perhaps deal with us or share with us any apologies that she may have received for today's meeting.
Thank you, Chairperson. Apology was received from Member Brett Heron and then also from Dr. Rosina Omar from Cape Nature. Thank you.
Nikar's line didn't come through well on my side. So hopefully it's only a problem with the download speed here on my side. So I'm asking that page 53 of our 57-page comments matrix, if I can use that word, be beamed onto the screen. I'm working from a document with the date the 27th of August 2021. Thank you. There we have it, the same document. So, ladies and gentlemen, I'm also from the National Department of Forestry, Fisheries and the Environment. They commented on clause 53, where they actually ask a question whether this section referred to a specimen of a listed species or also to specimens of species that are not listed. And the response from the department has been to refer to the definition of specimen, which I think puts clearly that it's not only listed species that is covered under this. Then clause 54, where they just point out that the scope of legislation that can be integrated in this manner must be limited and spelled out, as it can't include everything the CEO is responsible for. And our attention is drawn to the fact that this clause only refers to authorizations and not obviously the full task of the CEO. Then also from the National Department, they point out that the functions, mandates and duties of NCOs set out in Part 1 are very similar to those accorded to EMIs in Chapter 7 of NEMA, and they say that NCOs and EMIs that are mandated to undertake compliance and enforcement with similar but not the same legislative powers. Now, the department's response has been that, they don't differ from this, and that the bill provides for these powers in terms of replacing, modernizing and aligning similar provisions from the previous or the old Nature Conservation Ordinance, which will be repealed once this bill is adopted. Then also from the department, again, they point out that certain chapters of the bill are substantively similar to certain parts in NEMA, and also that it would be in the interest of the rationalization of environmental legislation in South Africa to delete parts of Part 1 of Chapter 9 that overlap with the provisions of NEMA, and that there are minor differences, and they believe that these differences might make it difficult for officials designated to enforce the bill. Now, the department is of the opinion that there is no difficulty in distinguishing between the roles, powers and functions currently, and they therefore disagree. The bill provides for these powers in terms of replacing, modernizing and aligning similar provisions from the Nature Conservation Ordinance. And many enforcement officers are also appointed as, for example, fisheries control officers, or in the case of particularly municipal officers as peace officers, and they have to navigate the relevant statutes and powers in any case currently. Then also in terms of the department, they have expressed that NEMA also provides for the monitoring of compliance, and it's actually a repetition of what they've stated before. And again, the department has said they disagree on the same grounds as the previous comment. 142, in terms of administrative enforcement, again, the first comment received from the National Department is noted, and then they again state that provincial conservation laws are very likely to be brought within the scope of NEMA's compliance monitoring and enforcement regime through NEMLAB in the near future. Again, we can only note that they envisage also to legislate in this regard. Obviously, it is not there, and we can only act with the light and the laws that we currently have available to us. Then 143, the mandate of nature conservation officers and also nature conservation rangers. Now again, their concern is that there will be two parallel sets of officials that can undertake compliance and enforcement with this action. And again, the response is, it is in any case contemplated in NEMLAB for there to be national and provincial legislation enforced by EMIs and or nature conservation officers. So this is not seen as problematic. Then in terms of comment 144, clause 59.3, the department expresses a view that this provision should be more explicit, and where the honorary conservation officers can only exercise powers when accompanied by a nature conservation officer, and the powers of honorary nature conservation officers are limited, and only those set out in clauses under 59.3 are covered by this. So it's not seen as a problem that the honorary nature conservation officers may not know what their duties and or rights are. Then 145, again, they say listing the powers of a nature conservation officer on an identity card may not be feasible. So again, it is noted by the department. It's not seen as a problem. Then in terms of clause 63, the routine inspections, there I think we have already adopted a position where we say that the word search may be problematic, and that I think we've already discussed will be replaced by the word examine the contents of any box, etc. Good. Then in terms of comment number 147, the National Department stated that this creates a parallel power to NEMA and compliance notices, and our department does not differ from that, and that they point out that the operational guidelines in the revision, that a revision thereof will be extremely important. Again, 148, again, the department refers to say that they are busy with a project to develop administrative penalties for the NEMA framework, which I think we not only note, I think we welcome that, but again, it doesn't affect what we're trying to legislate here. And then penalties, in terms of our clause 73, the fines in the penalty provision should be specified. Otherwise, the Adjustment of Fines Act applies, and then this has been agreed to, and our department recommends that we therefore amend clause 73, 1, to provide for the penalties, and I believe those are in line with the penalties in the other environmental legislation. Which then brings us to 150. They say, how is it appropriate to specify what a court can find? Now, perhaps our legal advisor can advise in this regard, but the response has been there's nothing unlawful in providing for such guidance, especially since their experience on the ground is that on requesting such remedies, magistrates regularly ask for clarity as to where such options are set out in legislation. And this is a discretionary guidance, and that is indicated by the word use of the word may in clause 74. Then again, 151, the question is asked whether in clause 75A and B it should be between them an and or an or, and our department believes it could be both, either A or B. And then 152, where the department has said that the CEO, they read into the bill that the CEO has all powers in relation to the sections in this Act, and this cannot be correct. The provincial minister also has powers, and the split between the CEO and provincial minister's powers must be made clear. The National Department is concerned that this wording suggests that the CEO can be exempt from any provision of the Act, where in fact the CEO only deals with authorizations. Now, our department is of the opinion that clause 79 is clear, that it only applies to authorizations. The Chief Executive Officer may, subject to any conditions, specify, and then it deals in A and B with authorizations and the conditions of authorizations. So that is not seen as a problematic clause. And then 153, where the National Department says what is deemed to where this is required. Everywhere there is reference to regulations, and they believe it does not make sense. And the response from the department is regulations are specified within the relevant clauses, which specify whether regulations must be drafted or whether they are discretionary, and therefore it is not seen as a problem. Good. Ladies and gentlemen, that then brings us to the end of this matrix, and I just want to give an opportunity to those present, if anybody would like to, on this, express a view, or perhaps would like to point out something which you would love to be clarified, etc. Now is an opportunity to do so. Honourable members, over to you first. No hands. From the officials, anything that you would like to point out at this time?
Chairperson Marlene Leross, just to note that some areas or some of the issues were discussed by the committee at their meeting in September, and so the actual final engagement around certain matters, and I'm just pointing to the example of the definition, for example, of well-being, as well as the issues in relation to clause 63, that there was an agreement in terms of the actual wording of those amendments in the matrix that we discussed yesterday, the first matrix we discussed. So those definitions and changes supersede the changes in a few places on this particular matrix we have projected. Thank you, Chair.
Good, thank you. Thank you, Ms. Leross. And ladies and gentlemen, I would then want to ask our procedural officer at this stage to please minute and note the appreciation of the committee. That is my proposal. For the large number of people, individuals and other entities that went to the trouble of studying this bill and that, served us with their comments, which I think is really great. The public participation from their side is really appreciated by the standing committee. That is my proposal, and that we thank them for their trouble and for taking this so seriously. And I think the fact that we have acted on some of them and that some amendments will in all probability, emanate from these input, I think is also a sign that we really appreciate that input. So that would be my proposal at this point in time. Thank you. Again, I take silence as concurrence with that proposal. Good. The next one, ladies and gentlemen, is that this was the long list of all the comments, and really I think everybody that did make an input would have seen that we take the input seriously and that we considered each and every comment that we received. And I appreciate also you as members' patience in this regard. If I could now ask whether Ms. Niekerk is perhaps able to just point out to us where we've agreed to amendments on the bill. Ms. Niekerk, would that be possible for you to beam that now onto the screen?
Yes, Chairperson, I'll do so now. There we go, Chairperson.
Good, thank you. It's on my screen and I trust everybody is therefore able to see it. Ladies and gentlemen, we're just going to quickly go through this bill and just concentrate now on the amendments and also to make sure that we don't miss one. Or obviously there's still an opportunity to propose further amendments. Before we consider this, obviously we now only looked at the input that we've received. And honourable members, you haven't actually had an opportunity, if you would like to ask questions on any aspects that were not covered by the comments received, etc. And I would love to give you that opportunity now. Should there be any other aspects of this bill that you would like to query or that you would like to, have clarified or something to that effect? Before we go to this list that's currently on the screen, now is an opportunity to also comment on other aspects that perhaps have not, been attended to by the various parties that commented on the bill. Are there any one of you that would like such an opportunity? No hands. Thank you. There was just one item which I personally found quite interesting. The current term of office of Cape Nature board members, I believe, is 5 years. And in terms of this bill, that term is now shortened to 3 years, with the option of the minister renewing a person's term for another for another 3 years. And I was just wondering, and I may be a little bit quick onto you, Advocate Marstorp and others, but my experience has been that, if a board only meets about 4 times a year, that it often takes even an experienced board member, people with experience from other boards and other governance structures, it does take you a few meetings before you really feel that you can make a valuable contribution and that you understand the environment. And I was just wondering whether 3 years may not be a bit too strict or too short for people to really be able to fulfill their governance role. And perhaps, Advocate Marstorp, you may be able to guide us in terms of, other councils, my experience of university councils and so on. My personal experience has been that, 4 years and so is rather the norm than 3 years. Would you like to perhaps just comment on the term of 3 years?
Thank you, Chairperson. Chairperson, the short answer is that there is no prescribed term. That firstly, even in the Companies Act, there's no prescribed term. A member of a board, a director of a board, may be appointed indefinitely even. firstly. Secondly, the term 3 years or the term 5 years is very much the discretion of the appointing authority in any case, whether it's an entity, public entity, or even a private entity, is very much discretionary. However, that having been said, we do know that directors, members of boards have a fiduciary responsibility in relation to the entity where they serve. They've got a governance responsibility in relation to that entity. And I agree that a period of 3 years is somewhat short and may even impact on a company's continuity at a particular level, or at an entity's continuity, in the sense that there may be a speedy turnover of directors, which in turn impacts on an entity's institutional memory and consistency, etc. So there may be those caveats in terms of a 3-year term. 5-year ordinarily is the norm. It doesn't mean that it is irregular to appoint a person for 3 years. 5 years, because of governance issues, because of the caveats against high turnover, and to ensure a degree of continuity and retaining institutional memory, etc. 5 years is ordinarily the preferred term. That having been said, it is the discretion of the appointing authority. There's nothing untoward, there's nothing illegal, there's nothing contra the Companies Act in that regard. It's a policy thing, and the committee can certainly make a recommendation because of certain concerns and caveats it may have, but there's nothing untoward about it. Preferred 3 years, preferred 5 years, but 3 years is certainly nothing untoward about it. Thank you, Chair.
Thank you. Thank you for that background, Advocate Marstorp. Honourable members, are there any views from your side as to the 3 years versus perhaps then 4 years for serving on such a board? As I've said, I am concerned because in terms of the fiduciary duty that Advocate Marstorp was referred to, you know, when you're appointed to such a board, obviously you're served with the financials of the last financial year, and over which you have had no control. You're in the middle of the next financial year or towards the end of the next financial year, over which you have got no control. And it's really, in my mind, quite difficult to make a meaningful input if you're only going to be able to influence 2 financial years in terms of, be it strategy, be it the implementation of those budgets, taking strategic direction, or using the budgets to give strategic direction to the entity. I don't see any members' hands. Ms. LaRosse, perhaps you can give us the background why you went for a 3-year term.
Thanks, Chairperson. I think it's very important to provide the background and the thinking behind this. Absolutely, the institutional memory and ballast for an entity like Cape Nature is absolutely a priority, very important. Further, what I want to point out in that particular section is that a member is appointed for 3 years. However, that membership can be renewed for a further term. So ultimately, should the member be available for a further appointment, in our experience, that is usually the approach. Unfortunately, also, you get situations where if you have appointed individuals for 5 years, and you find that perhaps the contribution is not as strong as you request or as you require, perhaps it's convenient to have a 3-year period. without needing to actually find or look at ways of or alternative means of terminating membership. So it provides an opportunity to the minister to also make sure that performance is tantamount to people occupying these particular roles, ultimately, as you said, to serve a very important governance means. So if you look at that particular section, a board member could be appointed for 3 years. That appointment could be then renewed for a further 3 years. And then there is also a further subclause which allows the extension for a further 1 year. So in the case of a performing member, an individual could actually be sitting on the board for 7 years as the approach. So the thinking behind that is it provides the level of flexibility to ensure the institutional ballast and coherence, bearing in mind we always working in the MTEF budget period, and obviously within the strategic planning periods in terms of the medium-term strategic frameworks, and that we've found this to be a good balance in order to ensure that there is adequate opportunity to deal with non-performance without going through dismissal processes, which are obviously also provided for in the Act. It also provides the discretion to retain that membership where there is performance, and even extend it for a further year. So we've found this to be the useful compromise to allow for performance to be paramount in occupying a place on the board. Thank you, Chairperson.
Okay, thank you. I'm satisfied, and I trust the other members as well with that explanation. You're quite right. To remove a member from a board is often not an easy process, and if you believe that having a member serving out his or her term and then not renewing the membership is the best way to go. You note my concern that if members only come and go at a fast rate, that again they are unable to really implement strategic direction and to fulfill their oversight role in the sense that just as you find your feet and start asking the difficult questions from the executives, that you then find yourself at the end of your term and therefore unable. And I think we've seen with many of the entities in South Africa the damage caused by a lack of good governance. So let's hope that the 3-year term as proposed by yourselves wouldn't hamper people, and that people asking difficult questions wouldn't find themselves out in the cold after 3 years because they are not recommended. I must share with you, it is a concern of mine, because quite often people even ask of executives to propose names or put names forward of people suitable to serve on certain boards. Okay, good. Thank you very much. Now then, honourable members, there being no other hands, let's continue then with the document in front of us, which is only then going to deal with the proposed changes, amendments to the bill. And the first one is then therefore the definition of environmental legislation. And you see the proposed amendment there in the 5th column. I hope you can read it. I'm going to try and see if I can enlarge it here on my screen. Thank you very much also to you, Ms. Nikat. So the proposed amendment that carried favour was to insert and includes any regulations or other subordinate legislation made in terms of these acts. Good. Again, I put it for informal consideration. Everybody agrees to that. The next one is the definition of export, where we want to add the words within clause 1, export, the definition will then include also or attempted transfer of any species or specimen. Good, agreed to. Then Agri-Western Cape, which asked us to include a recommendation or the reference to NEMA, and so the amendment would be to include the National Environmental Management Act, Act 107 of 1998, in the list contained in the definition of environmental legislation. Agreed. Then clause 1, City of Cape Town, that asked for a definition to be added, and that spatial development framework means a spatial development framework as contemplated in the Spatial Planning and Land Use Management Act, Act 16 of 2013, and that the Spatial and Land Use Management Act, is that necessary for us to repeat that?
Chairperson, on the matrix, the agreement was to include the 2 additional definitions, one for the Spatial Development Framework and one for the Spatial and Land Use Management Act.
Sorry, I find it a little bit strange. Do we need to define an act? I'm just concerned that, that act may be amended in the future, etc. Perhaps between Honourable Bartman and Advocate Maastop, you may just be able to help us. Do we need to, if you name an act by even referring to the act number and the year of the act, do you then again need to include that in your list of definitions? Over to you, Honourable Bartman.
Thank you, Chair. Chair, to my knowledge, very similar practices are done in tax legislation and financial legislation when, for example, definitions have already been set in law, but they're not necessarily in every single document. So then some documents will refer to other legislation where it's agreed to. Yeah, so I don't have a problem with that, especially if the stakeholder feels that there might be some confusion if the definition has not been included. Thanks.
Advocate Maastop, sorry, Ms. LaRose.
Thank you, Chairperson. And just to thank also Advocate Bartman for her input there. The reason why we need to include the definition for spluma is that we are now using it more than once. And rather than write out each time the full reference to the Act, as we would have done if we only referred to it once, we've now referred to it more than once. And hence, the standard drafting approach is to then include it as a definition, as we've done with other legislation. Thank you, sir.
Thank you. Advocate Maastop, you are happy?
Yeah, Chair. In fact, I was also just going to point out that the use or the insertion under definitions is simply because of the multiple use. Nothing untoward about that.
Good. Thank you very much. Good. Next page. Again, the definition of well-being. We've dealt with that extensively. So well-being is now defined. I thought it would say well-being as it relates to animals. Perhaps you could just help me again. Well-being means the state of, okay, that's correct. Ecological, behavioral, physical and psychological health of a wild animal. That is the one we considered yesterday. Agreed? Advocate Maastop?
Thank you, Chairperson. Just a correction. I see that you read the written definition there means the state of ecological, behavioral, physical, and then you said, Chairperson, psychological health. Now, I know that what is meant or what is written there is physiological health, It wouldn't have made any difference except that this meeting is also recorded, and I'm just concerned in future there may be a transcription saying that you read psychological, whereas in fact it is physiological, and that could be a dramatic difference. So for the record, the definition as we would have preferred is as follows: well-being means the state of ecological, behavioral, physical, and physiological health of a wild animal. Thank you, Chairperson.
Good, thank you very much. And my mistake, thank you for pointing that out. That's already adding value to this meeting. Then on the next page, a number of people commented on clause 5, the duty of the state, and can I just ask, the proposed amendment is then for us to add C and apply the environmental management principles in section 2 of the National Environmental Management Act. Is that correct? No comment. It's taken as concurrence. The next page then. Ms. Nikak, it is frozen here on my screen.
Chairperson, apology. I'm also getting a message saying bad network quality.
Okay.
I'm back online again.
If you could just go to the next page, clause 16. There was a proposal that we insert some words there for when the chairperson and the vice chairperson is not available. But then we yesterday learned that the drafting team does not recommend that, and that you would like us to stay with the wording as it is currently. Is that correct? What is the latest on that one, Ms. LaRosse? Can we just get clarity?
We have recommended for completeness, and so that we remove any lack of clarity, that for that proposed amendment is the addition of subclause 4, which reads: if the chairperson is for any reason unable to act as a chairperson, the vice chairperson, and failing him or her, the acting chairperson shall perform the function of the chairperson. So that would be to cover all functions, including the calling of meetings in that regard. So that's the comment from the committee, which we would like to support in terms of that change. In relation to the proposal to provide the CEO powers to call the meeting, we have recommended not to include that change in order to keep the executive and non-executive functions of the board separate. Thank you, Chairperson.
Okay, good. I understand now. So that the sentence that we have there at the top in green in the 5th column, that you support, but the other recommendations emanating from the meeting of the 14th, you say no. With that, I must say, with that change that we've got there on the screen, I believe it is clear, and it would give the board, if I can call it, an escape clause to function, even call board meetings, etc., in the absence of the minister, not appointing a chairperson and a vice chairperson. Thank you. Can we go on to the next page then, number 40? Sorry, clause 40. Clause 40. In terms of the declaration of mountain catchment areas, in terms of, I think, administrative justice, then to add the word that such landowners would be given a reasonable opportunity to comment, to add those words. Everybody is in agreement with that. Thank you. That then brings me to the next one, clause 40. Sorry, the next one is then clause 47, and there the proposal is that we delete clause 47.5. Good. That would be an amendment. Then clause 51.3, decision on application for authorization. We remain with 51.3A, B, but then a new one will be inserted, C, Biodiversity Act, and obviously then the old paragraph C will be renumbered D. Again, seems to have a general concurrence. Then clause 52, it's about risk assessments and expert evidence, and the proposal is that whereas the bill stated before granting an application, which implied that you cannot, do anything else but to grant an application, the preferred change now is before making a decision on an application for authorization, the Chief Executive Officer may require the applicant. Good. Thank you very much for that one. Then we move on to clause 63. I think Ms. Niekerk's computer or signal may again be delaying her paging through to the next page.
I'm back, Chairperson. I'm back.
Clause 63. We have dealt extensively with the concern that the word search may be a bit strong and even be, infringing on certain rights, and that the word search be replaced with examine the contents of any bag. Can I just say, Ms. Niekerk, I've got a slightly different one from what you have there. Is it inspect any bag or examine the contents of any bag? Perhaps we must just get clarity on that one. Advocate Master.
Thank you, Chairperson. My colleague Laros did indicate earlier that the word inspect is the preferred one. In fact, the matrix that we dealt with yesterday, as she indicated, is one subsequent to the one that uses the word examine. In our engagement between myself and the colleagues from Dr. P and Ms. Laros, we agreed after some engagement that inspect is the preferred word so that it falls within the constitutional bounds.
Good. Thank you very much. Okay, everybody happy with that amendment then as well? Good. And honourable members, that brings us then to clause 71, the addition of administrative penalties. And there you see it underlined that the following insertion is recommended. The provisions of sections 56, 57, 57A of the Criminal Procedure Act. And that is in terms of clause 71. Agreed to. Fantastic. Then the next one brings me to clause 73, where now the fines or the penalties are inserted in the bill. A person convicted of a category 1 offence as contemplated, and I think it has been agreed to. Perhaps I must just read it. A person convicted of a category 1 offence as contemplated in section 72(1) may be sentenced to A fine not exceeding 10 million rand, B, imprisonment for a period of not exceeding 10 years, or both such time and such imprisonment. 2. A person convicted of a Category 2 offence, as contemplated in Section 72(2), may be sentenced to A fine not exceeding 5 million rand, B, imprisonment for a period not exceeding 5 years, C, both such fine and such imprisonment, or D, in the case of a second or subsequent conviction, to Roman 1, a fine not exceeding 10 million rand, Roman 2, imprisonment for a period not exceeding 10 years, Roman 3, both such fine and such imprisonment. Paragraph 3, a person convicted of a Category 3 offence referred to in Section 72 in bracket 3 may be sentenced to A, a fine not exceeding 1 million rand, B, imprisonment for a period not exceeding 2 years, C, both such fine and such imprisonment, or D, in the case of a second or subsequent conviction, to Roman 1, a fine not exceeding 5 million rand, to Roman 2, imprisonment for a period not exceeding 5 years, or Roman 3, both such fine and such imprisonment. Everybody in agreement with that insertion in clause 73? And then the last one, clause 84, consultation. That a paragraph D of 84(1) be amended by the addition of a paragraph B, consult with organs of state whose areas of responsibility may be directly affected by the proposed regulations or notice. Good. Thank you, honourable members. That is then a summary of the amendments that we at this stage as a committee seem to be fit and to be improving the draft that is in front of us. Thank you very much for that. Now, honourable members.
Chairperson?
Yes.
Sorry, just to point out to you that because the additional definition was included for spluma, that clause 37 in the bill on page 23 makes reference to spluma as well as the act number and year. Now, usually when an act has been when it has been defined, there's no need to include the year and act number, so that needs to be deleted. That's clause 37. If you go down to line 48.
Sorry, I got my 7 and my 3 the wrong way around. You say 37.
Clause 37 on page 23 of the bill.
Good.
At the bottom, line 48.
Correct. So you say we delete under B. Is it just the words Act 16 of 2013, or is it the 2013 and then brackets then Act 16 of 2013?
That is correct. It's 2013 bracket Act 16 of 2013 close bracket.
All those words will also be deleted. Okay. Thank you very much. Can I say my impression is that now the next step would be for our legal advisor, Advocate Maasdorp, to go through these amendments, particularly as Ms. Nikak has just now pointed out, there may still be such anomalies, and there may be a need for some of the proposed amendments, and particularly some of the insertions, to be can I put it in stated in a legal language, or in that is, you know, can I say, in line with the language of the bill as we have it in front of us currently. So, honourable members, if it's fine with you, I would now like to ask that we refer the product of our deliberations up to now to Advocate Maasdorp in order for him to be able to to now go and go through the proposed amendments again and to ensure that the style in which these amendments have been worded at this point in time, that the legal and technical style of that is certified as being correct and in line with the remainder of the bill. Is that the next step, Ms. Niekerk?
That is correct, Chairperson.
Good. Honourable Bartman, I recognise your hand.
Thank you, Chairperson. Chair, I support the proposal by yourself. I would also just like to request that when the legal unit goes through the language of the bill, while I have not seen any reference to it, I just wanted to ask that we just please take cognizant of any language that is gender specific, and that if such language is picked up, if gender neutral language can then be used in the bill, please. Thanks.
Good, thank you. That is also noted with appreciation. Thank you, Honourable Member. Good, ladies and gentlemen, I would just like now to ask from Advocate Marsdorp whether you are ready to take on this task and whether we could perhaps consider meeting next week on the 19th again to then consider the product of Advocate Marsdorp's labour now between now and then. Would we be able to get feedback, let's say 2 days before then, so that we would be able to move to the next stage in the consideration of this bill? Advocate Marsdorp?
Chairperson, that should be in order for the 19th of November, yeah.
Okay, so hopefully you would be able to give us feedback by not later than the 17th, so that members would be able to go through any amendments that you may now propose in terms of styling and wording for this bill. Good. Honourable members, that brings me to the end of this item on the agenda. Our next item is the consideration of the minutes of the 4th of November, last week's meeting. At this point, I want to say thank you very much. This has been a lengthy process. I'm happy that from the committee side, we've really done everything to speed it up, and that we would be able to recommend the final product to the legislature before the end of this current term, and that hopefully this bill eventually would be able to be considered by the House before the end of this year. So thank you very much for everybody and for your hard work in this regard. I really appreciate it, and I'm happy and satisfied that we've had a very good and thorough process in dealing with this legislation, very important legislation that's also repealing a number of other ordinances and pieces of legislation. By the way, there was an interesting one where I was concerned about us repealing the Seashore Act of 1935, and Advocate Marsdorp was so kind to also advise me in that regard, to say that it's only those sections of the Seashore Act, which was a national piece of legislation, that was still remaining and that was still allocated to provinces, and therefore we acted within our right to ask for the repeal of the Seashore Act of 1935 as well. Advocate Marsdorp, would you like to comment specifically on that? And after that, I want to give an opportunity to Ms. LaRosse as well.
Thank you, Chairperson. Maybe not comment on that, but also just to thank and acknowledge my colleague Lionel van der Schijf, because before my engagement with you, I also just had a conference with him, and we are on the same page in that regard. So thanks to Lionel as well.
Thank you. And now over to you, Ms. LaRosse.
Thank you, Chair. I would just like some clarity in terms of the format that the committee will be receiving its further documentation. Would that be now in the form of an able? In other words, in the format of an able, which would set out the amendments in the legal language as proposed.
That is my understanding, but perhaps the officials could just assist in that regard.
That is correct, Chairperson. It will be in the format of an able.
Good, thank you very much. Mr. Ross, you're happy?
Yes, thank you very much, Chairperson. I just wanted to say before the committee moves on with their own business, just heartfelt thanks from our side for both the assistance from Advocate Maasdorp, yourself, Shireen, and of course this committee that is diligent in their work. Thank you very much, Chairperson.
No, and thank you. Thank you, and I'm looking forward to seeing this being turned into legislation, and particularly this being the guideline for many, many actions dealing with the environment, and particularly with conservation and with the Cape Nature Board. That would be wonderful for me to be able to witness that. Thank you. I see it's 10 o'clock, and I just got a message from Honourable Maseko that she's been affected by load shedding. I do hope we are still quorate. Perhaps Ms. Nika can just check on that. Mr. Ross, thank you very much. As you've heard, I envisage that we may be meeting on the 19th of November. It's a time slot that has become available on the parliamentary calendar. The 19th being, if I'm not mistaken, next week and Friday morning at 9 o'clock, if it's fine with those that are still part of this meeting, to then consider what Ms. Ross then named the A version of the bill. Good. Ms. Nika, can we continue? Are we still quorate with the consideration of the minutes of the 4th of November?
Yes, we are, Chairperson.
Okay, thank you. So, Ms. Ross, you and your team are happy to log off if you so wish. And honourable members, I present to you the minutes of proceedings of the 4th of November. Page 1, page 2. Good. Honourable members, can we adopt that? Honourable Bartman?
I move to support.
I see Honourable Maseko's hand is still here. I thought she might have dropped off. Honourable Maseko?
I second the move, Chair.
Good, thank you very much. Thank you for that then, honourable members. The minutes are then duly adopted. I want to thank you all for your engagement, your time, and I wish you well, and I'm looking forward to our next engagement. I think the next one is first on the annual report. Is that correct, Ms. Niekerk, for the Department of Environmental Affairs?
That is correct, Chairperson. It's on the 18th of November, Thursday, the 18th of November.
Good. And thank you with that. Thank you very much to you, and have a great day. Thank you.
Thank you.
Thank you, Chairperson and members.
Thank you, Shireen.
Thanks to everyone.
It's a pleasure.
Nice day.
You too, Member Moran.
Thanks, Shireen.
Thank you so much.